So I have an update for you in the Texas suppressor freedom case, which aims to stop the NFA and ATF's regulation of suppressors. So let's talk about this. But real quick before we jump in this video, if you think the NFA and GCA need to be done away with, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee. I drink it every single morning, and also I love them because they're huge Second Amendment supporters. If you buy some of their dedicated roasts for GOA or FPC, some of those proceeds go directly to those organizations so they can file lawsuits. And if you order and use the code ARMSCHOLAR, you can get 10% off of your order. So if you're interested, I will leave a link to Blackout Coffee down below in the detail section and also in the pinned comment. As I mentioned in the intro, in this video, we'll be discussing the Texas suppressor freedom case, which aims to eliminate the NFA and ATF's regulation of suppressors. The case we will be talking about is called Paxton v. Dettelbach. This is an important and interesting case which recently had oral arguments on cross motions for summary judgment, and those arguments took place just a couple weeks ago. All indications from those hearings before the court were that things didn't really go super great for the Pro 2A side. However, the state of Texas just asked the judge in this case for the ability to submit additional briefs, an additional letter to provide additional materials and support on their motion for summary judgment. And the court granted that request, and the state of Texas submitted a letter addressing the three main questions that the judge had for them during those hearings. And this is good news because Texas was given a second chance to submit additional evidence for why a motion for summary judgment should be granted against the ATF, and these NFA restrictions should not be applied to made in Texas suppressors. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that are made in and also remain within the state of Texas. The claim behind this law is that since these items are made and sold exclusively within the state, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. After Texas passed this law, the ATF then sent out a letter saying that they would still enforce the NFA's restrictions against made in Texas suppressors, and also they would enforce the law against anyone who made or sold these items. Now, Texas then filed a lawsuit against the ATF, and that's what's become this case, which recently had a hearing before a federal district court. In the original complaint, the state of Texas argued that the federal regulation of these items that are made and stay within a state is not permitted since the law does not impact interstate commerce. They also argued that the federal regulation of these items by the ATF drastically impacts the Second Amendment rights of individuals within the state, and also there is an impermissible tax on a right. The state of Texas' arguments were later then strengthened when the Supreme Court issued their recent New York State Rifle and Pistol Association versus Bruin decision. That Supreme Court decision set the record straight that text as informed by history is the correct type of analysis, and that means that the ATF must now justify their restrictions on made in Texas suppressors and other types of restrictions using that analysis set forth in Bruin. Now, multiple times in this case, the ATF tried to avoid this burden by arguing that the Second Amendment is not implicated at all because they argue that suppressors are not bearable arms and therefore they're not protected by the Second Amendment, and essentially that the ATF can put in place any regulation that they want. When it's convenient for the ATF argues in this case and other cases that suppressors aren't bearable arms protected by the text of the Second Amendment, and therefore also that Supreme Court Bruin decision doesn't apply. But when it comes time for the ATF to actually regulate these items, we all know that the ATF claims, and the statutory definition is that these types of items are actually considered to be firearms. So on one hand, they're saying that they're not arms, they're not bearable arms, that they're not protected. But on the other hand, when they enforce the statute's own definition says that they are firearms. Currently, this case is set to be decided on cross motions for summary judgment, and in simplest terms, a summary judgment motion can resolve the case in this whole dispute right here and now without a full trial. Both Texas and the ATF have filed for cross motions for summary judgment, and each side believes that they can win this case right here and now, and that's what the judge is going to decide. The main contrast in positions is that Texas argues that the type of arms which are protected are not just guns, they're not just firearms, but the Second Amendment protects all types of arms that are useful for self-defense. However, the ATF in their position is that only actual firearms will be protected under the Second Amendment. Texas also originally pointed out that the ATF's position that these items are dangerous and unusual is simply just not true. Texas quoted statements from the ATF's leadership during the Obama administration that expressly stated that suppressors are not dangerous by any means. Also, the ATF's own numbers show that 2.6 million suppressors are registered within the US. That means that suppressors in no way can be considered unusual. So everything seemed to be in our corner. We had solid facts, we had a new Supreme Court decision, and also a favorable district court in the state of Texas. However, all reports coming out of the hearing was that Texas attorneys might have dropped the ball on some of their arguments before that judge. But I think this issue was just remedied in some way by the additional letter and arguments that was submitted to the court and was agreed to be submitted by the court. The court permitted these additional arguments, and the letter addressed the three main questions that the court had during that hearing. The first question that they addressed in this letter was about standing. In this section, Texas argues that they have standing under the Supreme Court's recent Axon ruling. They argue in this letter that the court here should find that plaintiffs have standing to bring their constitutional challenges to the federal government's regulation of firearm suppressors without requiring plaintiffs to subject themselves to the allegedly unconstitutional process. What this involves is that the arguments that the ATF made in their replies and in their opposition to this lawsuit, the ATF multiple times argued that the plaintiffs do not have standing to bring this lawsuit because none of the plaintiffs have submitted made in Texas suppressors to the ATF for the NFA approval, and the ATF claims that standing will never be established until maybe individual plaintiffs submit those made in Texas suppressors to the ATF, and then the ATF denies the registration of those items, and until then, the plaintiffs won't have standing. Texas argues that the Supreme Court recently found that they are not required to submit themselves to the unconstitutional process. That is the question of the lawsuit. The next question is whether the Anti-Injunction Act bars the judge in this case from issuing an injunction or ruling barring the enforcement of the NFA because it involves a tax requirement. Current federal laws prevent lawsuits and decisions by courts which restrain the assessment and collection of taxes. The ATF claims that the AIA prevents this lawsuit in any judgment by the court because they would violate that type of concept. Texas argues that the AIA does not impact this case because the lawsuit's goal is to enjoin the enforcement of the statute's regulations and the duties that it imposes, including the requirement for the application, the registration requirement, and also the serialization requirement, all of which are beyond just a challenge to the taxation requirement. So they claim that the AIA is not implicated. Finally, the letter addresses this question and the big question, which is whether suppressors are under the Second Amendment's protection. In this section, the state of Texas argues that plaintiffs continue to urge the court that the question of whether a firearm suppressor is itself an arm is not the proper question post-Bruen. The Second Amendment protects conduct, not particular devices. However, to the extent that the court examines whether firearm suppressors meet their definition of arms, the answer is yes. In Bruen, the court defined arms broadly to include modern instruments that facilitate armed self-defense. Previously, the court had already recognized the historical inclusion of armor of defense within the definition of arms, showing the definition is not limited to completed weapons. Accordingly, because a firearm suppressor is a modern instrument that facilitates armed self-defense, it is an arm according to the court's most recent definition in Bruen. So in this letter, the court here allowed the state of Texas to submit additional arguments to support their positions in some of the main questions that were presented during that hearing. This is kind of a cleanup letter addressing all those major questions that the judge had during that hearing. It's also good that the court allowed Texas to submit this letter and essentially let them provide additional support for why a summary judgment motion should be granted in the state of Texas's favor. In my mind, this is good news because all indications coming out of the hearing were that the hearing did not go well for the Pro 2A side. So hopefully this letter helps to bolster some of those arguments that maybe were lacking during that hearing and will lead to a favorable decision. But that's where this case currently stands. If I get any more information, I will let you all know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.